Okay, everyone. Well, it is 5:05, so I think we can go ahead and get started. So my name is Katie Bushman. I'm an attorney at the Disability Law Center, and I am going to be presenting today on reassignment as a reasonable accommodation under the ADA. I'm going to go ahead and share a PowerPoint as well. And one thing that I'm just going to ask is that we hold questions till the end. And so if you want to put questions in the chat box or the Q&A, please feel free to. Just know that I'll get to them at the end, just to sort of make sure we get through the training before we answer any questions. So let me share my screen. Okay. And I think so. Hopefully everyone can see my screen. So again, this is going to be about reassignment as a reasonable accommodation under the ADA. The first kind of disclaimer I want to give is just that this is an informational webinar. It's not meant to be legal advice. It's not meant to create an attorney-client relationship with any of the viewers and the Disability Law Center. And as part of that, if you have questions, I can answer questions most likely if you've got them, if they're about the subject matter of this presentation, or if you need clarification. If you have any specific questions that are probably more like legal questions, you will just want to consult with your own attorney on that issue, and I can let you know if it's something I can answer or not. And I will have a slide at the very end that gives you an idea of resources where you might find an attorney if you would like one. So that's just a little disclaimer. The other disclaimer I want to give, I don't have a slide for, but for those of you that are not aware, on the Disability Law Center's website, we have an employment section. On that employment section, we've actually recorded and uploaded other webinars about relevant subject matters to this. So I know for sure we've got a reasonable accommodations one, and that one I would say is a good resource for you if you are looking for more information about reasonable accommodations generally. And I'll talk a little bit about them today just because reassignment is a reasonable accommodation, but I'm not going to go super in depth into accommodations kind of outside of reassignment. I would just point you to those videos if you have specific questions or want to know a little bit more about that. So today, the objectives of the webinar that I have for myself and for you to learn about is that I would like to provide you all with a brief background on accommodations, just because it's helpful to know a little bit about them before we move into reassignment. I'd like to explain and have you understand when reassignment might be appropriate in the workplace. I also am going to talk a little bit about what an employer is required to do under the ADA, and also what they're not required to do when it comes to reassignment as a reasonable accommodation. And then we also have some information about legal options if you are having trouble with accommodations in the workplace, or if your request is denied. So with that in mind, I'm just going to start with a brief overview of reasonable accommodations, and then some just general definitions that I think will be helpful as we move through this information. So reasonable accommodations fall under Title I of the Americans with Disabilities Act. And that title requires employers to provide reasonable accommodations to employees with disabilities. It applies to public and private employers who employ 15 or more employees. And then the provisions for reasonable accommodations say that these accommodations should be provided to employees with disabilities who are qualified, unless there is an undue hardship on the employer. So we'll just talk about some definitions. And there's the rest of that slide. So first, the definition of disability, or in the act it's called handicap, but we just use disability for purposes of the definitions. And so it means that you are a person with a physical or a mental impairment. That physical or mental impairment substantially limits one or more of major life activities or bodily functions that you have. And then for purposes of reasonable accommodations, that is either a current disability or it could be a record of a disability. And what that means, for instance, probably the best example I can give you right now off the top of my head for the record of disability definition is, for instance, if you were diagnosed with cancer in the past, but you're now in remission, you have a record of having a disability and therefore may be entitled to reasonable accommodations. There is one other definition of disability under the ADA. It's called the regarded as having a disability definition. Basically, people in this category are people who are considered to have a disability, but may not actually have a disability. And because they don't have a current or a record of a disability, they are not going to be covered by reasonable accommodations in the workplace because if you don't have a disability, there's not a protected need for accommodations. So the next definition that will probably be helpful as we talk about these topics is qualified. So again, an employer who is covered by Title I of the ADA needs to provide reasonable accommodations to qualified employees or applicants with disabilities. And qualified means that you are able to perform the essential functions of a job with or without reasonable accommodations, and that you have the skill, education, certifications, or experience necessary for that job. And again, that can apply to applicants. That can also apply to current employees. And then the definition of accommodations generally, there are kind of three ways that accommodations come up under Title I of the ADA. The first is a modification to like a job application process. And so if you are qualified, you're an applicant for a position and you have a disability, but you might need a modification to that application process. An example of that might be maybe you need an ASL interpreter at your job interview, and they don't provide that to people ordinarily. That might be a reasonable accommodation to ask for when you're applying for a job. Another type of accommodation under Title I is modifications to the employment that enable the employee to enjoy equal benefits and privileges of their employment. And then the third one, and this is, I think, the one that I see the most, is just where people are current employees and they need adjustments to the work environment or to the way their job is performed to allow them to perform essential functions. I've underlined essential functions because that's another important term that we would need to define to have a full understanding of accommodations. So essential functions are core to the position. And so basically that, there are essential functions to a position and there are marginal functions to a position. One example might be if you work as a receptionist and you answer phone calls and you're there to greet customers, and that's in your job description, those are probably core to the position, but you might also have some marginal functions that you sort of do, but are not the whole reason that you were hired. It's not possible for me to look at, all of the job functions of a particular position and know with certainty what is an essential function or what isn't. But generally, the employer will be able to kind of tell you what the essential functions are as part of a reasonable accommodation process. And so one of the things that need to be looked at, or some of the same things you need to look at when trying to decide if this function that you are performing or functions are essential or not, are, for instance, does the position exist to perform the function? So if I am a receptionist and my job is primarily to answer the phone and greet customers, if I needed an accommodation that eliminates one of those functions, that might be asking for an accommodation that eliminates an essential function. So those might be essential functions. Can other employees perform the function if they're distributed to others? That is one other consideration. Does the function require a specific skill set that you have? And then how much of the job includes that specific task? That's a really important one. that I think comes up a lot. And so these are just some of many considerations that an employer would look at and that you would want to look at to know if these functions are essential to your job or if they're marginal. And these are important to know, these definitions, because as I mentioned before, if you, even if you are a person with a disability and you are entitled to reasonable accommodations under the ADA in your work, an employer may not have to provide you with accommodations if they are an undue hardship. That's another term we probably need to define. And so that basically means the accommodation that you are asking for would be a significant difficulty or expense to an employer. And some of the things that go into analyzing whether something is an undue hardship would be the nature and the cost of the accommodation that you are asking for, overall financial resources and other resources of the employer, as well as the number of employees, and also the size of the employer. The type of operation of the employer can be relevant, and the impact of the accommodation on the employer. If there's a significant expense associated with the accommodation and they're not going to be able to provide it because it would pose an undue hardship on their finances, for instance, or their ability to kind of stay afloat as an organization, that could be problematic. And then this determination is kind of on a case-by-case basis by the employer. And so as you are asking for accommodations and working with your employer, this is something that they would need to analyze if denying an accommodation request. They won't just be able to deny it because they don't want to. Another reason, well, let's talk about a couple examples. These are long examples. I'm going to read them, but you can also read them as well. So this first one is that an employee with cancer is undergoing chemotherapy and is finding it difficult to keep up with their workload because the treatments leave them exhausted. As a reasonable accommodation, the employer transfers a few of that employee's marginal job functions to another staff member during the treatment period. The other employee is unhappy at having to do the extra assignments, but the employer believes the employee can absorb those assignments with very little effect on their ability to do the other things that they're supposed to do. And since the employer can't show that that would significantly disrupt their operation because there's someone there that can do the job and do those marginal functions when the employee with a disability can't for this period of time, there is not an undue hardship. An example of what might be an undue hardship is this. So another long one, a convenience store clerk with multiple sclerosis requests that they be allowed to switch their schedule from full-time to part-time as a reasonable accommodation because of their disability. The store assigns 2 clerks per shift, and if the first clerk's hours are reduced, the second clerk's workload increases significantly beyond their ability to handle their responsibilities. The store decides that the accommodation will cause inadequate coverage to serve customers, keep shelves stocked, and maintain security. And the employer in that situation could show an undue hardship based on that significant disruption to its operations and can refuse to reduce the employee's hours. However, if the request is denied as an undue hardship, the employer should still kind of explore with the employee other reasonable accommodations that might assist the store clerk without causing undue hardship, but might allow the store clerk to perform essential functions of their job. And so the other thing just about essential functions I wanted to make clear is that you can request reasonable accommodations to allow you to perform your essential functions, but usually eliminating an essential function from your job is not going to be considered reasonable. And that's kind of what this presentation is about. So just generally a little bit more background on requesting accommodations. How do you do it? I think a lot of folks who are watching this probably already know about this process, but I'll just kind of break it down. So a person or their representative just needs to let their employer know that an adjustment or a change to the work is needed due to a medical condition. So that's pretty vague. And I'll give some examples in a minute about what might be an accommodation and what might not be. But the notification can be in plain English. So you don't need to say to your employer a lot of specific information, as long as you've let them know that an adjustment or a change at work is needed for a reason related to a medical condition. You don't need to say ADA, Americans with Disabilities Act, or reasonable accommodation in your request. You can, you just don't have to in order for it to be a valid request. And then third, just no magic words are required in order to make a request or ask for an accommodation in the workplace. Accommodations are available to any qualified applicant or employee with a disability, and that includes part-time, full-time, or probationary employees even. And it includes, accommodations can include things like, I'll just go through a list for you, physical accessibility in the workplace, job restructuring, part-time or modified work schedules, obtaining special equipment that you might need to do your job, changing tests or training materials or policies, providing qualified readers or interpreters, and then what I'm going to talk about today is reassignment to a vacant position. Just wanted to give a few examples of requesting reasonable accommodations so you can see that link between the change that people ask for at work and a reason related to their medical condition. So first example, an employee tells their supervisor, "I'm having trouble getting to work at my scheduled starting time because of medical treatments I'm undergoing." That's going to be a valid request for accommodation. Another example, an employee tells their supervisor, "I need 6 weeks off to get treatment for a back problem." And I think this is the last example of an accommodation request that is valid, is that a new employee who uses a wheelchair informs their employer that their wheelchair cannot fit under the desk in their office. And then this is not going to be a valid accommodation request. An employee tells their supervisor they would like a new chair because the current one is uncomfortable. Although that's a request for a change at work, the statement is not sufficient to tell the employer that the accommodation, they're requesting an accommodation. Uncomfortable is not close enough to a disability-related reason to be pretty obvious. So in that scenario, if that were you, you would want to link the reason that you need a new chair to a disability or a medical condition. Okay. Just a few other things about accommodations. An employer doesn't need to automatically provide whatever you've asked for. So if there is an accommodation that you really want, but there's a less expensive alternative that is also effective, the employer can elect to provide that one to you instead. And really making this accommodation request or notifying your employer that you need something different because of your medical condition is just one step. It's like the initial step in the interactive process between the employee and the employer. And at that point, conversations should ensue to talk about accommodations that might work for you in the workplace. The employer is going to be allowed to verify that you meet the ADA definition of being disabled and what your needs are if it's not obvious. And that often comes up in the form of just paperwork that the employer provides for your medical provider to fill out. And then again, I said employers are not required to provide exactly what you want if there's an alternative that exists that is effective and that they prefer it. Okay, we're getting to reassignment now. Hopefully that was a helpful background that provided some context for what we are about to talk about. So reassignment under the ADA is a type of reasonable accommodation. It's actually listed in the statute and the regulations to the ADA. So that's kind of the first thing to tell you about. But it is considered the accommodation of last resort. So unlike some of the other accommodations I mentioned that can be implemented in your, kind of at any time if needed for a disability, Reassignment is kind of the last chance opportunity to see if there's some way to accommodate you so that you can stay employed. And then reassignment, so that you know, is only required by the ADA when the employee with a disability can no longer perform essential functions of their job, even with reasonable accommodations. So that's just like the broad bird's eye view of reassignment. And when might reassignment be appropriate? I think that's always a good question. Usually I see that come up. I see it come up that reassignment may be necessary is if there's been a change related to a medical condition or a disability that makes the job that you were previously able to do now not possible for you to do. And I also see it if an employer changes the essential job functions of positions, and sometimes that does happen. But just so that everyone is aware, reassignment is not available to people who are never able to perform essential functions of their job. That is an issue of being qualified for a position. And so if you started a job and were never able to perform the essential functions, that is not going to entitle you to reassignment under the ADA. So I've got an example of when reassignment might be appropriate for you. So an employee has been working successfully for 9 months when they become disabled in a car accident. The employee, due to their disability, is unable to continue performing the essential functions of their current position with or without reasonable accommodations, and they seek a reassignment. They are entitled to a reassignment if there is a vacant position for which they are qualified and it would not pose an undue hardship. So the elements are largely the same as accommodations generally. You're eligible if there's a vacant position or an accommodation available. You are qualified for that position and there's no undue hardship. So before you get to reassignment though, because it is the accommodation of last resort, it can be good to kind of explore kind of any option that you can think of. So for instance, if you are unable to perform the essential functions of your job with reasonable accommodations, but it's only going to be for a specific period of time, after which you might be able to perform the essential functions, you might consider asking for leave under the ADA. You might consider FMLA, that's the Family Medical Leave Act. You may be eligible for that depending on certain criteria. You might ask for temporary accommodations, and that could be, for instance, removing some of the functions of your position temporarily until you are able to, return to fully able to do them in the future. And job restructuring is also an option, which, I just, for temporary accommodations, just gave an example of that. So those are some options for you. But if you are not able to perform the essential functions of your job, even with reasonable accommodations, and you've gone through that process with your employer and talked about, reasonable accommodations in your current position, you'll want to know a little bit about reassignment and what that process looks like. So how does it work? You initiate that process like any other accommodation, letting your employer know that you need a change or something different because of a medical condition. I would imagine at this point, based on the process I'm about to outline, that your employer would already know that you need accommodations of some kind, because the first step is to look at whether or not you can be reasonably accommodated in your current job. The second step, if it turns out that you cannot be reasonably accommodated in your current job, then your employer needs to start looking for vacant positions with equivalent pay, equivalent status, equivalent benefits to what you're currently getting, and it needs to be a position that you qualify for. And then the third step, so if there's no vacant equivalent position, that's when the employer should look at vacant lower level positions. And bear in mind, your employer should be looking at new positions, different positions, in light of the fact that you might need reasonable accommodations in that position as well. You can still have reasonable accommodations in a new job, even if you're just being, reassigned to a new job entirely. One example of this is, let's say that you are a nurse for a hospital, and it turns out that you're not able to perform an essential function of your job. Let's say that you work in a particular area that's, causing, depression, anxiety, something like that. And you are trying to obtain reasonable accommodations in that job, but there really just isn't one that's going to allow you to be able to cope with the symptoms of your disability and allow you to do that job. You'd probably get to a conversation about reassignment. Your employer, again, should first look to see if you can be accommodated in your current job. In this hypothetical, let's say you were unable to be accommodated. Then the employer's next step is to look for vacant positions with equivalent pay, status, benefits. So maybe that's a position as a nurse in a different department dealing with a different type of, medical issue, or a different, area of the hospital or something like that. That's something that they should look at before they even look at any positions that are lower level positions. So if you request an accommodation at work or you request reassignment, your employer can't just immediately go to kind of the lowest paying job and say, like, here is the one we found for you. There's going to have to be some step or some steps on their part to look for jobs that are comparable to what you've been doing. And again, they should take into account any accommodations you might need in that particular position, because there are some accommodations that you'll just always need, possibly. And so that should be something that they're looking at as well. So what else should an employer do when you're going through the reassignment process? They should cast a wide net. So you're a nurse at a hospital. You can't work in your current department anymore, but you can still perform nurse functions somewhere else. The employer should cast a wide net. And what I mean by that is maybe that employer is a big chain of medical providers, and they have 10 hospitals across a state, and maybe even several in the same kind of geographic region. That employer should be looking at everything in that area and connecting with other hospitals as well. If there are vacancies, they can't just look at a very narrow, one narrow building. They're really supposed to look outside of that building when considering positions you might be qualified for that are comparable, that you could be reassigned to. So again, they should reassign you to a position that comes closest to your current position, assuming there's more than one position available. And that means, in terms of benefits and like pay and things like that. The employer is not allowed to make you apply and compete for jobs that are comparable when you're going through this reassignment process. They can ask you and make you compete for, let's say you see a job that you qualify for, but it would actually be a promotion in terms of like status and benefits and pay. That's considered a promotion, and they don't need to reassign you to a job that would be a promotion. But they can make you kind of compete for that and just apply through the regular channels. But again, they can't require you to apply and compete for a job that would be, a reassignment appropriate job, which would be like a lateral transfer and a job that is basically same or lower pay, status, that sort of thing. And then one other important thing to know is that the employer can't withhold reassignment to a vacant position to a qualified person with a disability who is eligible for reassignment, just because they are not the best qualified. So an example of this could be that there is a vacant position. Let's say you need reassignment, you have a few years of customer service experience, and you see that they're going to be hiring for a customer service position that might have some other functions you qualify for. Let's say that they're accepting applications for that particular position right now, and they receive applications from people who have 10 years of customer service experience, and maybe you only have 3 years of customer service experience. And let's just say that the position only requires 3 years of customer service experience. You're qualified for it. You may not be the best qualified for it in terms of years doing customer service work, But in reassignment land, that's okay. As long as you're qualified, that's where they should reassign you to that. They shouldn't be hiring people that are best qualified when they are undergoing this process with you, as long as you're qualified for that position. And then we've been talking a lot about vacant positions, and so that warrants a definition as well. Vacant means that a position is either available now. It could be that it's been posted and is accepting applications right now. Could be posted internally or externally, but it also doesn't have to be posted yet. It could just be that the employer, knows that it will become available within a reasonable amount of time. And reasonable amount of time is another one of those sort of terms that we would want to define, but I can't because it's determined on a case-by-case basis and sort of under the circumstances at the time. So just know that it doesn't necessarily need to be open right at this moment for you to potentially be qualified for that reassignment. As long as HR knows about it, or whoever's in charge of reassignment knows about it and knows you're qualified for it, they should, as long as it's opening within a reasonable amount of time, they should consider you for that for reassignment. An example, I think like this one. An employer is seeking a reassignment for an employee with a disability. There are no vacant positions today, but the employer has just learned that another employee resigned and that the position will become vacant in 4 weeks. The impending vacancy is equivalent to the position currently held by the employee with a disability. So as long as the employee is qualified for that position, the employer must offer it to them. And this is directly from guidance issued by the federal agency that enforces Title I of the ADA. And so this is, I think, a pretty good example of what may be a reasonable amount of time, could be a month or 4 weeks, as this says. So more about how reassignment works. Just want to tell you a little bit about what an employer does not have to do. They don't need to create a new position for you just to reassign you. So if there's not a position that exists, there's not going to be one that becomes vacant. An employer is just not going to need to make a job available for you. Similarly, they don't need to create a vacancy by terminating or transferring another employee. That's just not something they're required to do. Another thing is that an employer is not going to need to provide training to help the employee with a disability become qualified above and beyond what it would offer to any general applicant. So let's say that you work for a company and it turns out that you're going to need reassignment to another position, and you're qualified for another position, except for it requires some technology certification that you just don't have. Unless the employer would pay for any applicant to become proficient and receive that certification, then they don't need to do that for you in order for you to be reassigned to that position. It's just not one that you would be qualified for. The employer also does not need to reassign, as I mentioned before, reassign you to a position that would constitute a promotion, even if you are qualified for it. Again, that is something that you might have to compete for and apply for. For instance, if the pay is higher or the kind of status of the job or benefits or things like that are much higher. And then what else do we need to know about reassignment? Just that it might take some time to locate a vacant position. And so again, this is maybe where a reasonable amount of time comes into play, but also during this interactive process where the employer is talking to you about your qualifications and what accommodation needs you have, this process just takes time. So there might be a period of time where you are either not able to do your current job, or you need to have some discussions about that. So there are some options, and you would want to discuss these with your employer while you're going through this interactive process with them. So one option is you could use accumulated leave, or maybe unpaid leave is something that they would offer to you kind of on a temporary basis until something is located. Maybe they have an option where you could be temporarily assigned to a light duty position that doesn't have some of the same components that the job you're currently doing does have. And so maybe you're able to do that light duty position for a temporary period. And then one other thing to note is that an employer is free to go beyond what the ADA requires if it wants to. For instance, by eliminating essential functions on a temporary basis, or providing accommodations that are probably not reasonable, or are maybe too expensive, they would not really be considered reasonable. But if they want to go beyond what the ADA requires, they're allowed to do it. But they don't have to. They only have to comply with kind of the minimum requirements of the ADA. And then last, if your employer is still not able to identify a vacant position and you haven't seen any vacant positions either that you might qualify for, separation from employment could be the next step in that process. So that's just the general overview of reassignment and how that works. And just a couple things, maybe these would be helpful for you when you're considering if reassignment is the next best step for you. One, I think it's important for you to look at the job description of the job that you're doing. Maybe you have a copy of the job posting. Employers can be really good about putting essential functions in that job posting, but it can give you a really good idea of what are the essential functions of my job versus your experience with what might be marginal functions. And so that can be really helpful when you are interacting with human resources or whoever your employer is, so that you can talk about, can I be accommodated in this position? Or is it that I really can't perform these essential functions because of my disability? So that's one good thing to do. Again, talk to your employer as soon as you let them know that you might need something different, like a reasonable accommodation to a practice or a policy or something. Because of a medical condition, they're going to be on notice that might, be a thing that you need, and that triggers the interactive process. So they shouldn't, ignore you if you say something like that. Really, there should be a back and forth about like what your needs are, pretty early on in this process. I'd also say it's good to talk to your medical provider. So as part of the reasonable accommodation process, particularly if your disability is one that is not visible, they're going to be entitled to ask for information from your employer or from your medical provider about what your needs are, or about perhaps like the amount of time you might need an accommodation for, or something like that. So those are things that they're going to be able to ask your medical provider about, but also your medical provider is often in a really good position to work with you and know like what are your precise limitations, what accommodations might actually work really well for you. Whereas talking with your employer is more about, what are your needs in this position, and both of your needs in this position. And then the other thing I recommend to anybody is just to look at vacant positions. You're not going to know probably positions that are going to become vacant at some point in the near future. That's really, why you work with your employer, because they're in a position to know that. But they probably have postings that you could look at currently, so you can get a sense of what's out there, and you can compare, the job functions that you were able to perform with the job posting for the vacant position, and get a sense of, am I qualified for this? Is this something that maybe I want to ask for as a reasonable accommodation? Because I think if you can point to some positions that you qualify for, that can be really helpful for your employer as you are going through this interactive process. And then if your request is denied, and this is true, if it's a request for accommodation kind of generally, or if it's a request for accommodation for reassignment, if your request is denied, you're going to want to know why it was denied. So talk to your employer and ask why it was denied. You can tell them why you disagree. I've seen circumstances where a request is denied and it's just that there's not, specific enough information provided by a medical provider. And all you need to do maybe is go back and talk to your medical provider to kind of clarify some things. But it's always good to just continue that conversation with your employer, even if you disagree with their decision. And that's especially important because you can also ask for a different reasonable accommodation. You don't just get one shot to ask for a reasonable accommodation, and that's all you ever get. You can ask, for any that are needed at any time. even if your last one was just denied. And then also important, I think, is to ask if there's an internal grievance or appeal process. Some employers will have something like this, where if you disagree with a decision they've made about an accommodation, you can request that be reevaluated or maybe escalated to somebody else to take a second look. So ask if there's that sort of process, and that can be helpful to go through and perhaps get the accommodation that you asked for the first time. And then again, if your request is denied, those are sort of the practical things that you can do. You also have legal options. So in the state of Utah, if you want to file an employment discrimination claim based on a denial of reasonable accommodation, you have to file an administrative discrimination charge first. And the way that you do that is, got it listed here for you to look at if you want to take notes. The Utah Anti-Discrimination and Labor Division, or the Equal Employment Opportunity Commission. That first one is our state agency that works with the EEOC to investigate allegations of discrimination. You have 180 days from the date of discrimination to file a charge with UALD. If you don't, file within 180 days, or maybe you just would rather file with the Equal Employment Opportunity Commission, you can go straight to the Equal Employment Opportunity Commission or EEOC and just file your charge there, but you only have 300 days from the date of discrimination to do that. So that's a really important timeline to keep in mind, especially because under Title I of the ADA, you have to file a charge with one of these agencies before you can go to court. You can't just go straight to court with an employment discrimination allegation under Title I of the ADA. So it's important to be mindful of these agencies and their timelines. If you don't file a charge within that 300 days with the EEOC, you've just sort of like lost the opportunity to have your claim heard, both at the administrative agency and both in court. So just be mindful of those timelines. And then some legal resources that I promised about, where you might go for additional information or for legal resources. The Disability Law Center. So we are Utah's protection and advocacy agency, and we do employment law on behalf of people with disabilities. And when I say we do employment law, that means that we can provide information and referrals if needed. We can offer legal clinics depending on what your situation is. It just kind of depends on our internal kind of criteria at the time. So, but always worth calling our office, even if you get some information and a referral. And I'll also mention too, our website is really great. I'll mention again the employment section. There are a lot of fact sheets on there that can be really helpful. And I believe there are also sample letters on there that can provide you with a guide if you wanted to make a written request for accommodation. But those fact sheets are really great. And so please look at those as a resource to you. If you are looking for an attorney, kind of besides the Disability Law Center, licensedlawyer.org is a website that lists Utah attorneys. And these are attorneys that have, I think, asked to be placed on this list so that people know that they can call them and ask for a consultation. So that's a pretty good resource. Currently, the Utah State Bar has something called a virtual legal clinic. I don't know how long this is going to last or if it's going to be in person at some point, but the virtual legal clinic allows you to call and make an appointment where you can talk to a legal practitioner about your employment issue for, I think they're 30-minute time slots. So that might be an option for you, and it's free. I should mention that's free. And then the employment law clinic, there's not a lot of information about that available yet, but it's something that the S.J. Quinney College of Law in Salt Lake City is working on. It will be a free clinic. It's not clear yet if there's going to be income requirements, maybe not at first, but stay tuned for that. And the way that you'd want to find out more information about that is contacting the Pro Bono Initiative at the S.J. Quinney College of Law. And that is going to be a clinic where they can talk to you about any employment law issue, not just discrimination. At the EEOC, so EEOC.gov, again, the agency where you might file a charge of discrimination within 300 days. They also have information on their website that could be useful. So I've linked that there. And then also a lot of this information I provided today is directly from the EEOC's enforcement guidance on reasonable accommodations and undue hardship. We couldn't talk about all of the stuff that was in there today, but it's a really helpful, I think, resource for people who just want to know a little bit more about their rights. And maybe there are some nuanced issues we talked about today and you want to go look them up on your own. That's a really great place to get started. And then last, askjan.org. That's the Job Accommodation Network. And it's a website that is also helpful, not only to know more about your rights, but they actually have a listing of accommodations that are accommodations that have been particularly useful for people with particular types of disabilities. And so that might be a good place if you're in the middle of an interactive process, not sure what to ask for or what's even possible. Maybe you hop on askjan.org and take a look at kind of some of the things that they have experience with, and that could be a good place to get started with that.